Good morning, Your Honor.
Morning,
Good
Ron.
morning. Good morning. How's everyone?
Good.
Very
Good.
well.
Good. All right. Do we have everyone on this video conference that we need in order to go forward with our 10 o'clock hearing this morning? Or are we waiting on anyone?
I believe we
I know
can,
we're still a few minutes early, but go ahead, Mr. Galani.
I believe that we can go forward.
Okay.
Yes,
Mrs.
Your Honor.
Toman, is that correct? Okay.
Yes, Your
All
Honor.
right. Then I'll go ahead and call this case at this particular time. This is cause number DC 19-13868, Barbara Landry versus Richardson Crossroads Condominium Association. It's set this morning for the plaintiff's second amended motion for rehearing regarding a defendant's traditional motion for summary judgment that was heard by this court on November 23rd, 2020. So I am Judge Purdy, the new judge of the 95th District Court. Obviously, I'm going to be presiding over the hearing today. Let's go ahead at this time and have announcements. Let me know your name and who you represent on this matter.
Carlos Galliani for the plaintiff.
Thank you,
Clara.
Mr. Galliani.
Clara Tolman. I represent Richardson Crossroads Condominium Association.
All right, thank you. Okay, so Mr. Galliani, this is your motion, correct?
Yes. Well, we'd just like to briefly preface this with, the court having plenary power for a certain amount of time after the motion for summary judgment, with an additional, motion being filed to extend plenary power, which I believe was treated like a motion for new trial.
Correct.
And the previous hearing was heard on December 17th, I believe. So almost a month ago. Defendant's motion for summary judgment, Your Honor, relies on evidence that has been controverted by affidavit. And this evidence is new evidence that now they've had an opportunity to examine, to respond to, and they have not responded. That what is contained in the affidavit and the new evidence, I guess, that we're controverting is not true. So basically, I believe our evidence shows that there is a issue that is a fact issue that needs to be considered.
Okay, let me ask you this, and I did read the plaintiff's second amended motion. I know that there was a response filed there too, so I read both of those. What is the new evidence that is proposed that was not available back when you all had the hearing on December 17th?
The substantive new evidence that has not been refuted is that this incident occurred not on the plaintiff's patio, balcony, not on any land or apartment that was deeded to her, that was owned by her. That this in fact occurred 14 to 15 feet from her front door in basically her front yard, which was owned by the Condominium Owners Association. And all of this is controlled by a master deed written by the Condominium Owners Association. So I guess the terminology that was used in the original motion for summary judgment has changed, and there's more clarity, I believe, on whether the plaintiff owned this area or whether she controlled the area, and where it occurred.
Was that not known during the hearing when you all had the hearing back in December?
We relied, unfortunately, on the defendants' attachments, their exhibits, and their statements that this incident, this trip and fall on September 5th, 2017 occurred on her patio. That they stated this occurred in this in their diagram, in their motion for summary judgment, in a shaded area that was an element that would have been the owner's responsibility. Since then, we've looked at where this occurred. We've gone back to get our our client's affidavit, and now we can definitively say where this occurred. And that was, I think that was a major reason that the court went and looked at the Lee versus Wynn case. And in that case, it would, I guess it would support the defendant's arguments if this occurred on her balcony or on her patio.
Your
as
Honor.
it's
Okay, Mrs. Tillman, I'm going to allow you to respond to the argument heard counsel present to the court.
Your Honor, so your question was this evidence not known when we had the original hearing? The evidence was there. So it's not like something new came up or something that they did not have the ability to find out, because that's really the standard. Did you have the ability to find this evidence? They did. I mean, they could have easily gone to their client's house months, when they signed her up, to find out where this occurred. They've had a lot of time. They've had almost 2 months after I filed my motion before the hearing to, if they were going to dispute that fact, to bring up what they were going to dispute from my motion. They never did before the hearing took place. And now they lost. They're like, well, let me go look at the place. Let me see where exactly it happened. The place has been the same place ever since she moved in there years ago. Nothing has changed. So it's not that they did not have the ability to find that out. So I have not responded to it because my position is that they're bringing new evidence that was not brought up before we had the hearing.
All right, counsel for the plaintiff.
I believe we have a right to do what we're doing. What we're asking the court is to consider our plaintiff's affidavit that was filed that is allowed under the rules of civil procedure in a motion for rehearing. And then I don't see anything in the law or under the rules that are what defendant is talking about.
Your Honor, when it comes to MSJs, and MSJ is treated like a trial. And in my response to the first motion for rehearing, I did bring up a case, Horton versus Stovall, where the Fifth Circuit says evidence attached to a non-movement's motion for new trial, which is essentially what this is, should not be considered additional evidence. So it's just like a hearing. Then MSJ is like a trial. So it's the same thing that you would do if we had gone to trial on the merits. You don't get to bring up new things after the fact and say, oh, hey, the jury would have, decided differently if they would have known this thing. Like, that was your shot.
All right, counsel for the plaintiff. Any particular cases that maybe contradict? I've not taken a look at Horton versus Stovall. I will take a look at that. But any particular cases that the court may take a look at?
I don't have them right now, Your Honor, but I just read the sections that apply in O'Connor's. So I believe there are certainly cases. I've just asked for time to review those and submit those, and also review the case the defendant is referring to, Horton.
Okay. All right. Do you all know whether or not there's proposed orders that have been submitted, uploaded in the court's file with respect to the motion that is before the court today?
I filed one yesterday.
Okay. Do you know if the plaintiff has an order on file?
Not on this current second amended, though, so it would have to be refiled.
Okay. If you'll go ahead and refile an order, and by filing, I simply mean, upload it to the court system, I can pull it down. And then when we conclude this hearing, because I know my court reporter is on, I will give you my email address as a courtesy. If you want to send me one or two cases that you think are in contradiction to Horton versus Stovall, you may. I don't know that you need to respond any more than just the cases, because I'm going to read the particular case that defendant has indicated in her argument. I'm going to ask that you copy Mrs. Tobin on that email just as a courtesy so she knows what you have sent to the court. And I'll ask that you just attach your order as a courtesy.
Okay, thank you, Your Honor.
Okay, this concludes our hearing. We'll go off the record. I didn't want my email address to